today we are going to have a very interesting conversation about succession planning for digital assets. And I'm very happy that I have some of my legal colleagues on this particular call, because as we go along the conversation, we do find that there's a bit of work for us to do when it comes to definition of what are digital assets and really capturing all that within the law as it sits. The fact that our law is broad and purposive, such that we can always get nuances in terms of interpretation, I think moving forward, we will require a very bespoke regulatory framework when it comes to digital assets. For those of you who have never joined us in any one of our webinars, my good name is Mudhoni Njogu. I'm a practicing advocate at Njogu and Associate Advocates, and I'm the managing partner. So other than presenting our clients in court, we also have this platform where we are able to discuss matters affecting the law or matters where there's the law, there's an underlying element about it. So allow me to kick off the conversation by just going through along my presentation. And I wanted to start off just to have a broad perspective of what the law or the legal framework when it comes to matters of succession. Our default thinking or process has always been that it's only the Law of Succession Act. But when you think about the law in its broad sense, it touches on other issues when it comes to matters succession. We always need to look at the legal framework that touches on succession law in this country. And we start from the very supreme law of this land, which is the Constitution of Kenya 2010. So one of the components when you think about the Constitution is Article 40 of the Constitution, which provides for the right to property. And as we are going to go along, we're going to find the various definitions that we can try and extract from a broad sense so that it can apply to digital assets. And then, of course, we have the substantive statute that is the Law of Succession Act, Cap 160 of the laws of Kenya. We also have the Industrial Property Act. And the reason that this particular act is in this particular list is because a patent is transferable. Just the same way we are able to transfer land, we are able to transfer shares, a patent is also transferable as a part of an estate of a deceased person. We also have common law. Sometimes you realize that there are no definitive statutes that are really talking about a subject matter. So part of the law for the non-legal participants who are on this call is also made through judgments and rulings in court. And I give a great example when we think about the Employment Act. There are so many things that are in that Employment Act of 2007 that some things have almost been, can I say, overtaken by events where now judges have made rulings about issues within that particular act. Just to give context, I'll give an example of a person who is on probation. We didn't think that we needed to give this person, when we are terminating this person, that we need to take them through the motions of having to hear them, etc., like a fair hearing before you terminate. But now the law has changed to the extent that you need to actually have a hearing for this person to be heard before you terminate their services. Skimming through the list, of course, we have the Matrimonial Property Act. We have the Marriage Act of 2014. I do know that you have come across, when we talk about matrimonial property, that passes on to the deceased wife, or if it's the other way around, it's the deceased husband. And then we also have the Public Trustee Act, where there is no person that has been appointed to manage your estate. You can have succession under the Public Trustee Act. But we'll get to the nitty-gritties as we move along the conversation. We also have the Trustees Act, where, if, for instance, we are talking about children, there may be the formation of a trust so that children can be catered for until they have obtained the legal or right age in accordance with our Kenyan law. It will be foolhardy of us to talk about succession when we don't appreciate how succession flows within our current Kenyan law. So succession in Kenya is basically in two ways. And I know that I've added a third methodology down there. So we have the succession when a deceased person dies testate. That is when they have a written will. It could either be oral or it could either be in writing. And then we also have intestate, where the deceased person or definitely has died without a will. And then nominee succession, we will definitely get this much more details as we run around through the conversation. So testate succession just basically means that the deceased person had drafted a will, which could either be in writing or it could be an oral will. So in written format, the act is very, can I say, malleable. It doesn't give you a format of how exactly a written will is supposed to be. So the question becomes, if I write my will in a code format, nowadays we have what we call, I think they are called smart contracts under what we call the blockchain technology. Would that suffice to say that that is a written will? The law actually does not have a hindrance of how that should look like, as long as it can actually be interpreted to see the real intentions of the testator when he was alive. Secondly, we also have the oral wills. So the oral wills, the law provides that if I make an oral will today, it is only effective for the next 3 months. There's a little bit of a caveat when we think about persons in the military. So for persons in the military, you appreciate our officers, KDF officers, the environment, the work environment, anything is possible. And because of the imminent danger, the law allows them to actually make a will, which does not have the strictures, the real complete strictures of it has to be in a certain way and format, so that they can be able to, declare the intentions for their beneficiaries. Of course, for a will to be valid, one, the testator must have testamentary capacity to do so. That means sound mind, he's of legal age, etc., etc. So a will is administered by having the executor who now writes the will is also has two witnesses towards the will. And these witnesses don't have to be in the same room at the same time. So a will be held that it's not valid if for one instance or another, it was drafted where there was force, coercion, undue influence, and either the testator was not a person who had capacity or was on unsound mind. But again, unsound mind is such a broad and general term. So there are diseases that allow people to have what we call lucid moments, where they can be able to interpret a couple of things. And at that particular point, if they have such a particular disease, then that will be valid because they have those lucid moments where they can be able to articulate themselves and draft the will. So one of the key things about the Succession Act, even with this right to declare your intentions, to say, what do I want? To say my dogs should be given to XYZ, or my house should be given to my wife, etc. It has a limitation. So the law acknowledges that you have the liberty to share your bounty as you deem fit, but this right is not absolute. And that's why you see these places where we find that a benefactor or a beneficiary is going to come to court and say, I wasn't given reasonable provision. And if sometimes we have given all our estate to a charitable organization and we have left none to our beneficiaries. So there are certain limitations which are, of course, case by case basis. Authenticity of the will, for it to have effect, is done through what we call the grant of probate. And there are steps towards this of how you go to actually have the will effected through the court process, which is not a subject for this particular webinar. And we are going to have that discussion in another webinar. But the grant of probate gives the executors who have been left to execute the deceased person's intentions the ability and the authority to actually distribute his estate. It cannot be gainsaid what exactly are the benefits of a will. And we have seen prominent families in this country where we are fighting about property. And I remember at a time where there was I got into connection with the Biu Koinange case. And Biu Koinange had been in the judiciary system for close to 30 years. by the time the estate was being decided in court, some beneficiaries had actually died. It was a good thing for lawyers because we got work, but at the end of it all, it had withered down, it had taken so much time in court because of the acrimony of that particular matter. So it cannot, as I said, it cannot be gainsaid. What are the benefits of actually having a will? So the next category of succession in Kenya is intestate succession. So intestate succession, this is where you have left no will. So you are now going to follow the processes of the law. The court is going to decide a couple of things on your behalf. And it's also a place where in a will, in the previous context of a tested will, the executor can say, I don't want to do this any work anymore. So that is a question of what we call renunciation, like you don't want the role anymore. So assumably one of the executors, if there were two, one died, one renounced his ability to actually continue with the will, to execute the will, then this might actually go to the intestacy rules. So intestacy, the will, there are rules about how to go about intestacy, who can be appointed as the administrators. Normally, if you're able to agree as a family, even if there was no will left, it is well and good. And then we have intestate succession, whereby we have the public trustee. The public trustee comes along where the deceased died intestate, and nobody has really taken up the mantra of executing the will. And then the person named as the executor is dead, or has also renounced probate, and the deceased, of course, either by his own volition, appointed a public trustee. As I said, there is a third category of succession. This is what we call nominee succession. We normally don't pronounce this as much as the two other categories of succession. So for nominee succession, you know, when you go to the bank, you write my next of kin is so and so, whoever is going to get my benefits is XYZ. And we see that a lot, especially under the Companies Act. We see that a lot under the NSSF Act. If somebody died, and of course, either you are the spouse of the person, then we'll see that a lot, that you have nominated a particular person. And we also see that in the areas of SACCOs, where you nominate somebody to actually be the beneficiary of some of your benefits. So the law has been very clear on this, and the judges have actually pronounced themselves on this particular issue. And they said that if somebody has been nominated as one of the, can I say, benefactors or beneficiaries of that particular if it was a share, or if it was a SACCO share, or if it was NSSF pension funds, then this does not form part of the estate. So by virtue of the nomination, whoever has been appointed as the beneficiary is going to be the person who goes home, can I say, with part of the estate. I've always said, and it's clear because I see a lot of this in my area of practice, where administrators who are appointed under the intestate succession, or executors appointed under testate succession, really taking on a sort of demigod power about their role. But in strict sense, their role is to actually manage, collect, and manage the assets of the deceased person, and of course, transmit it to the rightful beneficiaries. Anything to do with the estate that is not in accordance with the wishes of the testator, or is not in accordance with the family in terms of the intestacy rules, then that is what we call intermeddling of the estate. A great example is when there is a bank account for some reason, because you're the administrator with the grant, you go ahead and open the bank account, and then you start using that money without the consent of the rest of the family, who are also beneficiaries to the estate of the deceased. So from a general perspective, we now understand what is succession, intestacy, testate, and of course, nominee succession. Knowing that is not the key thing. It's if that will happen, I'm going to die intestate, what exactly happens that I can sort of mitigate some of the pressures that probably would come with intestate succession. You start what we call estate planning. There are various tools to do estate planning. The basic tool for estate planning is a will. There are other more dynamic tools for estate planning. It can look at trusts, you can see insurance policies, you can see gun pet control trusts, you can see trusts themselves. So there are various tools, but the basic tool for estate planning is actually a will. And of course, there are objectives for that because you're able to protect your assets. And especially if you have a business, we do know of some Kenyan companies that have gone down where there's no proper even business succession. You can be able to, give to your charitable bequests. You can be able to cater for anybody who has any level of incapacity. You can be able to mitigate on the taxes that do accrue. You can be able to cater for minor children. As a definition and by the law, so we want to plan our estate, but we need to understand what exactly comprises of an estate. As I said, the supreme law of this land acknowledges that any person has a right, either by themselves or in association, to acquire and own property of any description and in any part of Kenya. The section is quite wordy, but I took that and also subsection 5, which says that the state shall support and promote the intellectual property rights of the people of Kenya. In the bigger definition, when we look at our constitution, the purpose to also help us grow our jurisprudence, I highlighted and bolded the word property of any description. We want to see at the end of it all, does this capture digital assets? So the Law of Succession Act also, it defines what is exactly free property of a deceased person. What is this that this person has the right to bequeath to their beneficiaries? So an estate is defined as the free property of a deceased person. And I give examples, that could be movable property, that could be movable property. So when we're thinking of immovable property, we're saying where the property is taken into, where the property is situated, that is taken into consideration. If, for instance, you made your will in the UK, you have property in the UK, it can also be given effect here in Kenya by what we call resealing of the grant. Again, we'll get into the finer details, and not in this particular webinar. We want to get straight into the digital assets. So movable property as well is also included when it comes to the estate of the deceased person. I hope this has now given us a preamble to now look into what exactly are digital assets. Digital assets, there is no universal definition of what exactly is a digital asset. There has been trials to try and define what exactly is it. And in the world that we are living in today, we are always leaving footprints or our marks in the internet. That could be through social media, that could be through, we are working either through Upwork, such applications that allow us to do online work. We are always leaving some digital footprint in either way or not. And this, of course, creates what we now call a digital estate. So you have a couple of things all over the internet, this creating a digital estate. We have things like digital files, digital records, email accounts, domain names, digital carbon credits. We are now selling carbon credits to other countries. We also have crypto tokens. We have the NFTs. We have our engagement with the metaverse. And in all these digital assets, you will find that the technology behind all these assets can be materially different. It doesn't have to be the same. For instance, if I was talking about crypto tokens and NFTs, the technology behind them is what we call the blockchain technology. So the blockchain technology is basically, for me, I defined it as a ledger. So an NFT is a non-fungible token. So it is a specific digital identifier to ownership of something that it can be replicated in the current world. Like, for instance, if I bought a painting, that can be now, that painting can be made into a certain way, into a code that can be identified, and I can be able to sell it online. So we also have crypto tokens. There's now so much hullabaloo in our country about crypto tokens. The Capital Markets Authority wants to try and come up with some format of regulation for the same. So digital assets are defined. We actually now have, from a Kenyan perspective, some semblance or some attempt to actually define what are digital assets. The Finance Act of 2023, which some of you all appreciate that now we're in court, but the green light has been given for it to proceed, tries to define digital assets in terms of anything of value that is not tangible, cryptocurrencies, token codes, and numbers held in digital form and generated through cryptography. I don't know about you, but the nuance that comes out of it, and the reason why it was defined was specifically to entrench the digital. They want to tax crypto assets. So the definition is quite specific in that regard. So it doesn't encompass the earlier definitions that we are trying to put in, like digital records, email accounts, and things like that. So it really doesn't get into those specific, but I think it's a very good attempt to trying to define that. My biggest caveat when we're trying to define digital assets is with every technology, there's something new that is coming up. So we cannot box them into a certain, say, this is the number of things that can be included in digital assets. So the law is, the content is always changing. I have had an interest in the blockchain sector. And I can tell you the things that were being discussed in 2021 are not the things that are being discussed in 2023. So things change and move very fast. So it needs some form of elasticity to accommodate all these definitions of what exactly are digital assets. As I said, you have digital footprints, and these digital footprints are now what aggregate become your digital estate. So again, if we go back to our legislation, we don't have that definition. The Succession Act tells us that free property is what we call movable, immovable property. The Constitution also encompasses the intellectual property. So there is no clear definition of how to deal with your digital assets from a succession perspective. Other jurisdictions have tried to seal this gap because it is important that even for any legislation to take effect, it is important, one, to define what exactly they are and their scope. Other countries have tried to do that, narrowing it down to things like personal and business emails, attachments to emails, websites, records that were formerly kept in a safe deposit box, etc., etc. I could go on and on. Bottom line, even for them from those developed countries, we still don't have a box of what exactly are digital assets in the entirety, or a global definition that could actually capture digital assets. If that be the case, then where does that leave us? One, let's first appreciate what are the challenges when it comes to digital assets. When I open up a Facebook account, my name is Mudhoni Njogu, you will find me on Facebook. But when I die, really, the platform provider has its own self-regulating mechanisms of what is supposed to happen. So it provides that if my friends want to, have memories of me, they'll have to show either a death certificate, they'll have to show either a grant that they've actually been granted, all that. And in some instances, for example, like Twitter, deactivate account. There is no, we can memorize what Mudhoni did, etc. Nothing. For Gmail, we have what we call an inactive account management feature. Recently, they updated their policy that if you are not active for the next 2 years, which effect it will start, I think in December this year, if you are not being actively using your Gmail account, then they will shut it down. Of course, they give you the options like Safaricom that if you don't use your number for quite a while, will also shut down. Looking deeply into that policy, it says they are going to notify you. They're also going to notify your security email address, etc., etc. So as I said, one of the challenges becomes access, because it's these platform providers who made a contract with me. You remember every time that you're signing up into all these platforms, they ask you, do you accept all the, do you agree to the terms and conditions? Normally, there's nobody else there. It's normally you. It's very daunting to think that somebody has been very active on Twitter and then everything else just is deactivated because the person has passed away. An example of how this happened, in a case that I came across I think in the American system, a soldier had died and his parents wanted to memorize him with all the emails that he had been sending and everything, so that at least they can create some form of a collage about him. But they couldn't do that because at that particular point, Yahoo said, no, we don't give out information, because if we do give out information, then it means all our subscribers, we have to give them information. At that particular time, Yahoo had about 40 million people. I do believe those numbers have changed. It's not one of the most secure email addresses. For crypto organizations, if you do own any crypto, you have either owned this through what we call exchanges, exchanges like Coinbase. I do know most of you have heard about Binance, etc., etc. So for Coinbase, for instance, they ensure that at the point where you're naming your beneficiary, this is done together with your estate planning attorney. But I must confess, I think trying to open that account, it doesn't have all that legal requirements. So, but that is the procedure. They say if there was some money in somebody's account in that particular exchange, that of course you have to follow due process, give us the death certificate, give us grant. And the same case goes for Binance as well. But what I realized about Binance, it has an extra layer, which I found really disturbing, because it says that you can have all your passwords in an online platform called LegPass. So they say you are able to protect all your access codes online in one place and anticipate their transmission in case of trouble. I think that portends more trouble than solutions. I want to go to the recommendations. Our law is clearly inadequate. It is inadequate when we talk about digital assets. There is no clear definition. What we have, and I pray, is that the courts are able to interpret every situation that comes towards it so that it can build on the common law. If you do remember a while back, we lost one of the greatest, I think he was, an MC or something, Big Kev. So Big Kev wrote a will in 2015. It had all the validity, everything. Then fast forward, he started becoming unwell, and he had his sister and his wife as the executors. And Big Kev changed his will, which was already written, into a video recording. There is nowhere in our act that provides for video recorded wills. So it provides another lacuna, which our laws are not in tandem, or they have not been changing in tandem with the realities of the world, that I can actually make a video recording of my wishes. But the judge in that particular case was quite flexible, because she went back again to look at the rules of evidence. How do you bring in electronic evidence in a matter of court? So basically, she relied on the Evidence Act as opposed to the Succession Act, because the Succession Act, as it sits today, does not encompass video wills. It doesn't. So my recommendations, and I think this is a subject for more research, just to also try and see what do other jurisdictions do if they actually have some sort of leeway when it comes to digital assets. From my, can I call it little research? Really, there's no hardwired. Everything has been left to the courts to widen this scope in terms of the law. So when it comes to crypto assets, I think one of the key things would be, as a form of investment or whatever it is, you get assigned a key. It's like the lock, it's like your password. So at the point where you're drafting your will, it is important to see that you have multi-signatories to that particular key, because the key is, it's like your password. If I say my password is Smudoni Njoku, so MU is probably with somebody else, is probably with my accountant, TH is probably with somebody else. So that at the demise of the testator, those keys can now be, patched together, and they can be able to open up the wallet for purposes of accessing the crypto tokens. There was also another recommendation that in my reading that I saw, we call what the dead man switch. So the dead man switch means actually a complete company came with this remedy to try and see if somebody has not been active, almost similar to what Gmail is now trying to do. Because there are certain things that if I'm active on my account, there must be some level of human interaction. We'll pretend are big problems because we are moving into the era of AI, but if we are talking it from a strict sense, if somebody has not been active, it triggers certain kind of actions that can now slowly just lock up your account. Of course, from a legal perspective, it is important that even for the lawyers of on this call, that it's a clarion call to us to try and expand this space. From a parliamentary perspective, in terms of expanding the law and include digital assets as part of definition in the Law of Succession Act. I saw an interesting feature where Rwanda's data protection law offers for a succession of personal data. I did not see quite a similar provision in our act. So ladies and gentlemen, that is my brief and short presentation on digital assets. And I do believe this is a question of conversation and more conversations and discussions to be had in the future, where even if we want to leave everything to the interpretation by the courts, it is time to also agitate for a change where we can see some level of definition and scope and all that when it comes to digital assets.
We are here, great presentation. I have no questions, quite knowledgeable.
All right, thank you. A question here, do you think the law is slow in catching up with technology? Absolutely. And the law is not just slow from a digital assets perspective. The law is slow in everything when it comes to technology. But one of the key things, and in my engagement, and especially with the blockchain sector, what I have learned is regulators are never confused on their roles. So technology is great, really great, but at the heart and soul of every regulation or every regulator is the idea that you must protect the consumers. So I think that's why the push and pull normally comes in. So the regulators are still remembering their goal or their DNA, which is protect the consumers, make sure everything is okay. But at the same time, that goal sometimes can be a stifling effect when it comes to technology. So that's why you always find that regulation follows innovation. Caleb, you asked about the process of expanding the succession law. Let's start with the small, can I say the low-lying mangoes? The low-lying mangoes would be how you move parliament for change of laws. That was the low-lying mango. You normally start with a memorandum, just highlighting the inadequacies of the law. What is inadequate to the sense that we cannot always rely on the broader purposive authority of the Constitution to always bail us out. We can always have a statute that is very quite definitive so that any court of law, whether a magistrate court or high court, can just get direct to that determination. So of course, we start with the memorandum to Parliament, and of course, highlighting what are the areas of the law that we do desire change. Then from that point is go through the motions of discussions, and then finally, if approved, definitely there will be a change in the law. Great presentation. In your opinion, who do you think are some of the key stakeholders we need to step up to fill in this regulatory lacuna? Wow, you had almost tested my Kikuyu. Who are the stakeholders? The stakeholder is you and me. Is you and me who own Facebook accounts. The stakeholder is you and me who owns property that is in the digital economy. The stakeholder is me who has some crypto tokens which have not bequeathed to my beneficiaries. You are the stakeholder. Sometimes it's always interesting that we want somebody to come in to save the day, but it's a simple write-up. I do know that you've witnessed how much comments and action took place when the now the act passed. Every person who was aggrieved by that was in those sessions, trying to articulate why that law should not pass. So the stakeholder is definitely me and you. A question from Stackerman, is there any country in Africa that has included digital assets in the law? Not that I know of. But when we look at digital assets from a crypto perspective, As you have seen, the meaning is expansive. From a crypto perspective, there are countries that have tried to do that. So we have South Africa has done that, Namibia has done that, Botswana has done that. Ghana has done that to the point where they allow for what we call sandboxes just to try and test all these innovations. But from a crypto perspective, crypto is just one component of digital assets. As we've seen, digital assets are so many. So from that perspective, there are countries that have done that, that have defined digital assets the same way our finance digital assets. But for me, as I say, that was more geared to try and understand that from a tax perspective. There is conversation that is occurring with the Capital Markets Authority. There was a bill that was actually not tabled. It's still pending somewhere in January this year. We are hoping that that will also see the light of day at some point, and of course give fine-tune the definition of what exactly are digital assets. But globally, so far, we haven't seen any. And of course, there's that fear that if we do define, we will not be as elastic as possible, almost case-by-case basis when these matters come to court, but there must be some level of definition that gives us scope. Any final question or comment from any of the participants?
Okay, I have
If
a question.
Not, okay.
Mine is on the first slides of your presentation on succession. How is a property, how much time does it take for a property to be taken back by the government? I am an non-law background, so that's why I'm asking. Probably an asset has been unclaimed, but it's nowhere to be found.
Nowhere to be found. Financial asset or a physical asset? Tangible,
Land,
like
land. So
I don't think there is really a timeline. And of course, any lawyer in the group could also help and assist. I think we had a similar issue, and the matter was before now the public trustee. But this had happened almost, I think, 2 years ago. So there's really no timeline that I do know of. But of course, that is subject to more clarification. I will say that I'm not quite certain. But if there's any lawyer who can also confirm, but Tabitha, I'll also take your details just to confirm from the law whether there's any particular timeline. There is a question from David Kogi. For instance, you worked in a company and later you left and the employer asked you never to include the company in your CV in future. Are they allowed to have your photos all over their social accounts, and who owns this media? May it be photos or videos recorded when working under the company? So David, one, I would go back to your employment contract, but from a data protection perspective, no, they are not allowed to do that. But because I don't know the complete nuance of your employment contract, what it provides or what it entails, from a data protection perspective, nobody as a company is allowed to use any of your photos. Those are your rights. That's your right to privacy of how your photos are disseminated within the interwebs. So it's you who decides whether you want to do that on Facebook or whatever social media, but no company is supposed to do that. We have had numerous cases where organizations take photos of people, and when they do this, the Data Protection Commissioner has been awarding penalties to those organizations. I think there's also some court cases. I remember one from Machakos where a certain lady's photo was used to market a university. I think it was a university or a technical college. So they were also fined for the same. So from a data perspective, standing, nobody's allowed to do that. It's illegal now. So please use your data protection rights for that particular purpose. You have a claim. So I think one of the key things that I would want to, leave as a parting shot, it is possible to have your digital assets in a will. It is possible. It is how you are able to entrust the executors of the will, or whoever you're going to leave your, the process of bequeathing to the beneficiaries, if you're able to draft it up in a way that they can get access. The problem has been access. So if you're able to leave such good guidance on how that is supposed to go through, you can actually leave the keys with the bank, for instance, like part of that has been left under the authority of the bank, such that upon your demise, if you probably had a lawyer, they would connect the bank and then they would be able to have access, the passwords and etc. So it's very possible. Ladies and gentlemen, thank you so much for your participation in this particular webinar. As I said, this is an area of law that will keep evolving, but I think we can always do our own little housekeeping within ourselves. Do write a will. At the very least, I remember a judge saying, the very least, write a will. And in this will, designate to us how your Facebook account is going to be, is going to move on to your next beneficiaries. Maybe it was earning money. So please do write a will. Thank you so much, ladies and gentlemen. Do have yourselves a wonderful, wonderful afternoon.